Ladies and gentlemen of the jury, I will have to ask you to render your verdict after hearing me. If you don't understand, you will never get to the truth. Okay, I am getting sick and tired. I'm 84 years old. I came to the United States from England, although I was born in India. I thought America is a land of opportunity. I came to the United States with my 3 daughters, aged 2, 5, 7, and 9 at that time. I wanted to give you a brief outline what has happened. When I first went to a company called Michigan Bell Telephone Company in Detroit, Michigan, I was found very happy with my immediate boss by the name Jack Temple. He was observing me as if everybody coming there is a terrorist or whatever it is. And I got up from my seat around 10:30 or 11 for my morning coffee, which is 15 minutes. And by 11:15 I will be back in my seat. While in India, people go to work at that time. We have to go for lunch. So that's the way, that's the difference between India and the United States. Now, what I wanted to tell you is, this is a story about discrimination based on national origin, color of skin, discrimination based on age, and discrimination based on everything else. America is not, I wanted to repeat this, I want the whole world to understand, it is not a country free from discrimination. It feeds discrimination. Those who hear me, those who understand me, what I'm talking about. In my case, as I told you before, I was working for a white person by the name Jack Temple, who found me very qualified. He found me very punctual in my work. He called me and asked me my background education in India, which was a BA in Bachelor's in Economics, Political Science, History, and English. And I also studied nearly 3 years for my LLB, Bachelor of Laws, from the Faculty of Law, Delhi University. It is at the time I fell in love with a young girl who was very poor, but she was beautiful. I married her, and we lived for the next 16 years. When my employer then fired me without a cause. In order for an employer to fire an employee, there ought to be a cause, a reason. In fact, in my case, I was given a merit increase of 5,000 a week earlier, and I am being fired the following week. The reason was the employer was laying off people, but they had offered all others 3 years of MIP benefits, Management Income Protection Plan. It was not given to me, they discriminated me. They held me to economic ransom and blackmail for several days. They sent an undercover agent to my home by the name James R. Williams from Michigan Bell, to persuade me not to picket in front of AT&T. They got the wind because once the world come to know they are laying off people and discriminating Mr. David alone, then it creates eyebrows. After hearing the commotion, the heated arguments between me and Mr. James R. Williams, my entire family came to the scene and avoided what would have been a murder scene. Because those days, people are allowed to keep a gun on them. There was no restriction. You can have a concealed gun. That's not important, but that's the tactics employed by the corporations then. It was at that time President Ronald Reagan had appointed a Catholic priest. He was later on found to be a mafia. He busted unions. Okay, that's all history which I unraveled by going through the C-SPAN and 901 pages of the FBI report, for and against. That is my latest discovery in the year 2020. So now I'm going to talk to you what happened to me. The employer fired me after I refused to take the money. They literally held me and my children to economic ransom and blackmail until I was forced to sign a release. We have a copy of the release which you can see, and later on I filed what is called a complaint pro se. I demanded $10 million from the employer for illegal violation in terminating my services, and later on I engaged a lawyer from Chicago by the name Syriac D. Kaplan, who was the president of the Catholic Association. I didn't know all this, that's all recent discovery. I went to see him in Chicago, hired him. He came with me to my home. He interviewed my wife and children to make sure that I am not lying. So they told him what happened. Mr. Kapil accepted the case and filed an amended complaint. Okay, that is marked here as P3. And after he filed the complaint, amended complaint, the case went to John A. Reed Jr., who allowed him to proceed pro hac vice. And the judge ruled there are triable issues of material facts in the case, whether I quit the job on my own or I was fired illegally in violation of the United States laws. That's the issue, sole issue. Now the defendant couldn't prove it. If they proved their case, I have no case. Then 43 years gone by, the employer could never prove that the release obtained from me was valid or not. So they engineered various schemes. You got to understand. The employer secretly hired the trial judge's law clerk as their counsel. They were meeting each other at their homes and other places in flagrant violation of the canons of ethics for the judge. And this woman, her name is Anne C. Conway. She was also committing a violation of the Florida law by meeting the judge. She admitted, and so the judge. They were meeting. I reported both of them to the FBI and to the former Chief Justice Warren Burger, who ordered Judge Reed to recuse and resign, and he resigned, Judge Reed. Now this woman, although she was a co-conspirator, because she is conspiring with the judge, she was rewarded by making her a federal judge in the same court in Orlando, Florida. Okay? A co-conspirator. She was never cleared by the FBI. If the FBI had investigated what she was doing, she would never have been cleared by the FBI. She was hastily appointed as a district judge. Then soon after that, she was appointed as a chief judge. And I started putting out a lot of stuff into Facebook and YouTube about what is going on. About 14 hours of videos. So when they started hitting, she was hastily transferred to the FISA court. FISA court is a court where terrorists are tried and executed based on politics, not based on the law. We all know it. What is politics? Carter Page was one of President Trump's close friends, and he was also convicted by this woman, issued a warrant. She issued a not only warrant, he was later on tried and sentenced. I don't know what happened afterwards. Now, this is a political game. It is not a just game. Now, after the judge was transferred, judge was forced to recuse and resign, he passed the ball on to his chosen successor by the name Terrell William Hodges of Tampa. Tampa had nothing to do with me. I never lived there. Never lived there. Not even one day. I was there for an hour with my children for fishing in Clearwater. That's my nexus to Tampa. So under the political game, this case was assigned to him. I was living in New York at the time. This judge sent me a notice demanding or ordering me to appear before him for a conference. I went to the court, although I was unemployed then, because what they do is, when you fight a case, they blacklist you. Anywhere you go, you don't get hired because they badmouth you secretly. I sued the city of Miami when I had a score of 98.6 in a competitive test. I won the case. I settled it for around $18,000. So my claims are not without merit. My claims are. I have a lot of cases in the United States. I had another case where I was working for an accounting firm which is run by Jewish people, and the girl who was sitting next to me, she won't do her job. Her job was to purely entertain the partners in their respective cubicle. So we ran into a problem with this woman who is a chain smoker, and she has bad habits, and I was fired from there. For what? Again, same discrimination. That case remained in the Kangaroo Court again. I never got a dime, although the federal judge, Miriam Siderbaum, offered me $10,000. I had spent by that time for discovery alone more than $20,000. So I didn't take it. They fixed that case. Okay, you have to understand what is going on here. We are not talking about the law, we are talking about the political ability of one party or the other to influence the judges. And they simply bowed to the politicians. Coming back to my case, this judge, Hodges, kept my case without conducting a trial, which he was required. Under the scheme deployed by the defendants AT&T and Michigan Bell, they fired a division manager by the name Orville E. McDonald, who was working for AT&T in New Jersey, like me working in Florida. So they are creating a law, not what is on the books. They wanted to create a law. That idea was you have to tender back the money to the employer. That was not the law on the books then, but they tipped the right people. So the judge, a state court judge, ruled Mr. McDonald must tender back the money to the employee. The clerk altered that, and the order of the court was to dismiss the case without prejudice. The clerk altered, he entered a judgment on the merit, and the 11th Circuit Court of Appeal got the case after the defendant's learned counsel Peter Wolf, Zinnover, and Anse Conway filed a brief alleging that it is a final judgment on the merit. You have to see their jurisdictional statement, which is entirely false, devoid of merit. Okay. Now, the defendants lost everywhere. They lost. They couldn't prove the release is valid. They couldn't prove the tender back is required because the Supreme Court once again denied the tender back defense in a case called Aubrey versus Enderby. Understand? So the defendants lost everywhere. Now, I raised the issue before the US Supreme Court because the ruling of the court below was wrong. Under the rules of the Supreme Court, if there is a conflict between one circuit with the other on important questions of law, the Supreme Court has the authority under Rule 10 to grant certiorari or mandamus. In my case, case number 16-9624, the Supreme Court, while denying my appeal, held. You have to watch the important words used by the US Supreme Court, which says on line 4, unless petitioner pays the fee and submit the brief. Important point. If the Supreme Court didn't mean what it said, then they would not have put it there. They meant what they said. I submitted my brief on time. Also, the $300 bank draft made payable to the clerk of the court. Now, before I did that, another clerk by the name Mr. Atkins, Jeffrey Atkins, returned my papers. He this time quoted in his letter that the right case number, okay, here are we. So Blalock letter, just of the next letter from Jeffrey Atkins, dated February 16, SP 22, and when I responded to him, he said another letter, P23, April 10, 2018, raising a constitutional question. The clerk of the court has no authority to question the Supreme Court's order. His job is purely ministerial to carry out the court's order. So he raises a question, constitutional question. The defendant's counsel never raised a constitutional question. Does he have the authority under the rules? He found no other defect. Okay? He could have returned it saying that either the font is wrong or the page length or whatever it is. They never raised any question. His rationale for returning is he couldn't understand the Supreme Court's 5-line order. I mean, the 6-line order, wherein for line 4, it said, unless Mr. David pays the fee and submit. Okay, that's the name of the game. Now this case was repeatedly returned by the clerk after clerk. And I had no option. I moved the disciplinary committee of the DC Bar, everywhere corruption. DC Bar doesn't want to reprimand the clerk of the Supreme Court. So they didn't assign this a case number. It went to, not to the chief prosecutor at the DC circuit, it went to a lower level woman who refused to look into, and this game continued. So next 5 years, the game went through the Columbia circuit. One of the judges by name Carl Nichols, who ruled my complaint should be limited to 15 pages double-spaced. There is no way somebody who went to college and studied English at the college level can write a brief containing 15 pages double-spaced. Okay, so he was wrong. He denied my motion to file electronically, which was previously allowed because of the COVID, and I had served the 7 parties, and all the parties were served. I also served them by separate mail. We will see the acknowledgement due, which never came back saying that they were not delivered. Okay. The bottom line here is, folks, there is a discrimination, and the discrimination is compounding. They are trying to make life difficult. They can shop around, buy time. That is one of the tactics employed by the employer. When you have no merit, they have to apply delaying tactics. That is what they did. The bottom line here, ladies and gentlemen, the Supreme Court granted me permission to file a writ of mandamus, which was repeatedly denied by the first clerk, M. Blalock, alleging and showing a different case, which is not what is before the court, and the successive clerks. The question here, those who wanted research, is the tactics, the crude tactics. The defendant lost throughout. they couldn't prove the release signed by me, 2-page release is valid. If they can't prove the validity of the release, what do? You have to settle it or concede. In humiliation, they have to admit, which they don't want to. So, the bottom line, folks, is they deployed tactics after tactics after tactics. One of the tactics they deployed was asking a federal judge at the 11th Circuit, who is retired already in the year 2012, to rule on my case. He had no authority to rule on a case when he is already a retired judge. He denied second Judge Marcus. He also denied both were retired and they have no authority under Rule FRAP 35 to review the decision of the court below. You understand? So the question is, the Supreme Court granted the permission. It went on further, no end. All that the employer has to do is pay my money for which I paid into the damn system and settle my ADA, Title VII, ERISA, and breach of contract. So the case is still going on. And the US government says you have to go this and that. When you go into the system, you can never access their system from India. You can never access. The phone number, nobody knew what is the mystery. They said for India you have to type plus and 91 and the phone number. When you type, neither they get nor I can call. So I'm now going back to Atlanta this week, I would say not this week, next week, to face them, to tell the world how they play games, how many millions they spend to play games, and to prolong my agony for 43 years. I'll be carrying my placard, and those who want to support me, come down to the EEOC office. I don't know whether they will allow you, but I'm going to stand there until the present media come to my rescue. Thank you, ladies and gentlemen. We look forward to meeting you shortly in Atlanta. Bye.